Good afternoon. My name is Riley Morelli. I am the Volume 33 Senior Forum Editor for George Mason Law Review. I'm honored to introduce the moderator for Panel 4, Rethinking Monopoly Maintenance in the Digital Economy, Scalia Law School's very own Professor John M. Yoon.
Thanks, Riley, and thanks again for everyone for joining us for this Panel 4. Let me just start with introductions. I know we haven't been doing that. I've noticed the norm has been jump right in, and you're like, please keep doing that. But I did want to at least give titles and introductions, and then I'll talk about the format of this panel, which is slightly different from the other three. So with that, let me start with Nicolas Petit, who is joining us remotely from Europe. I'm not quite sure where, but it looks very European over wherever you are. He is a Scalia Law visiting professor, chair in European competition law at the European University Institute. He has affiliations with UC Berkeley, and he's also the co-founder of the Brussels School of Competition. Joining us here in person is Giovanna Massarotto. She's a lecturer in law at the University of Pennsylvania Carey School of Law. Real pleasure to have her join us. And then we also have Thomas Nachbar, who is a professor of law at the University of Virginia School of Law. So with that, what we're going to talk about is maintenance of monopoly, or monopoly maintenance, however you want to say it. And the format is the following. So Nicolas has a new paper that will eventually be published, and he's going to share his ideas, which I think are quite provocative, about the US doctrine on monopoly maintenance, how it perhaps is underdeveloped, and it's missing a certain element doctrinally. And so Nicolas is going to walk through those arguments for us, and then we're going to switch gears and almost like a workshop, have Giovanna and Tom give their reactions and thoughts, agreements, disagreements, and we'll see how much time we have left at that point and see if the audience has any reactions or questions. So with that, hopefully the technology will work. We have a plan B if this doesn't, which is kind of interesting. So in some ways, it might be cool to see it. But let's move to plan A and see if Nicolas is ready to go.
Okay. Right, can you see the slides? Great. Can you hear me well?
Yep, you're good to go, Nicolas.
All right, thank you, John, and thanks everyone. Good afternoon. It's a big honor to be part of this symposium. I'm very sorry I cannot join in person today. Also, heavy snowstorms are currently sweeping across where I am, between Italy and France. And for now, the Wi-Fi is holding up, but if I suddenly vanish, we have a plan B, as John was saying. Something will take over. Okay, now I want to start with a number. And that number should bother anyone who associates antitrust law with the basics economics of price. The number is $20 billion. So this is roughly the sum that Google pays Apple every year to be the default search engine on the iPhone and other devices. Last year, the district court for the DC circuits saw this check as a violation of antitrust law. Judge Mehta, in his opinion, concluded that Google was a monopolist and Google was found maintaining monopoly power by buying exclusivity. Now, anyone with a basic training in economics should ask, wait a minute, since when does a monopolist pay tens of billions of dollars for the privilege of doing business? And the party pocketing the $20 billion check is typically the one with the market power. So this is the paradox of the price-taking monopolist. And this paradox, this is my submission in the paper, is not anecdotal. Monopoly maintenance law is underdeveloped, and if it is applied in the way it is designed today, it creates the risks of misdirection regarding liability. This is a problem because antitrust cases increasingly feature, and I mark my words here, the specific claim that a firm is unlawfully maintaining a monopoly, right? And the claim is specific relative to the claim of acquisition of monopoly. And in reality, that firm may, in some cases, be only responding to the monopoly power of its trading partners. So in my paper, I trace this error to the established analytical approach. Again, I quote here, established analytical approach. You can find these words in the Microsoft opinion, conclusions of law. The established analytical framework of monopoly maintenance developed in Microsoft and prior cases. And under that established analytical framework, the focus is on whether the conduct is exclusionary with a twist. The plaintiff is allowed to take an analytical shortcut. A court may infer, these are the words of the Microsoft court, infer causation instead of establishing causation. So plaintiffs can win with a fairly simple showing. They only need to show that conduct is reasonably capable of contributing to a monopoly, right? All right, so now the problem with that established analytical framework is that it evades two key questions. First, is the monopolist actually or potentially losing power? And second, if yes, is it utilizing its residual dominance to impose restraints on a market with weakening monopoly? So the Microsoft case, I go back to the previous slide, allows liability findings based on a sort of side-by-side showing. You show a monopoly structure, and then you show competitors losing ground. And the mere juxtaposition plus a conjecture, the reasonably capable label, are enough to find a Section 2 violation. Correlation is treated as causation. We are not far from the I know it when I see it antitrust offense. Okay. Now, consider the Google search case. So, did Google have an objective incentive to exclude rivals from the iPhone? And the answer is no. I mean, the court's own admission was that search rivals did not pose any threats in the near or midterm to Google. And the record also showed that Google had the best search engine in the market by far. So if Google didn't have any exclusionary incentive, why would it pay $20 billion a year? There are three likely answers to that question, and I don't think any of them support a Section 2 liability claim. The first option is that the payment may be the result of basic corporate paranoia. Executives fear, and we know this, threats that do not exist. But antitrust law is not here to sanction subjective fear. It should require a finding of objective market foreclosure. Subjective paranoia does not meet the willful maintenance requirements of Grinnell. The second possibility is that the payment may be a preemptive deal to keep Apple out of the search market. That's not science fiction. There is evidence, again, in the record that Apple was investing very heavily in search capabilities. So if Google pays to stop Apple from building its own search engine or disincentivizing vertical integration in search, the case should be a case of horizontal market division. That is a Section 1 violation. And in that scenario, the victim is actually the co-conspirator. So by forcing this into a Section 2 box, the court might have misdiagnosed the conduct. And plus, the remedy in the Section 1 case would be drastically different from the type of remedies we discussed in the context of the Google case, things like breakups and so on and so forth. All right, the third possible explanation is that Google basically entered very early a distribution deal with Apple for search that became increasingly costly as year passed with the success of Apple's products. So the cost rose year after year, and at some point the Google negotiator asked, and we can see that again in the opinion, what do we get in return? And to justify the massive payments, they might have required an exclusivity that they actually did not need or would have no effect in the market, just as a sort of, hey, we didn't walk out of the room with nothing in the pockets. All right, now let me. I created this with ChatGPT, I think, not Gemini. Now let me move to another case that I discussed in the second version of the paper that I'm working on, the FTC versus Qualcomm case, which shows a similar kind of failure in monopoly maintenance law. So in that case, the district court condemned something that's known as the no license, no chip policy of Qualcomm. And the district court based its holding on the Microsoft precedent. The allegation was a classic tying claim, where Qualcomm was allegedly using its dominance in the modem chip markets, chipsets, to force handset makers like Apple to license its patents. The government theory in that case is complicated, maybe overly complicated, and odd. Qualcomm owns a lot of standard essential patents, which give it a legal monopoly in the licensing market. So why would Qualcomm need to leverage chips to maintain a monopoly it already legally owns through IP rights? So the only possible reason is that the OEMs are not taking licenses and are behaving as monopsonists in the licensing market. They hold out of lawful licensing. The court never really expressly considered that possibility. By the way, there's another puzzle in the case, which is that the court sanctioned Qualcomm for threatening to withhold chips from OEMs, but at the same time objected to Qualcomm paying financial incentives to OEM to buy chips. So how can Qualcomm be the price setter and the price taker at the same time? I mean, this is very odd. So the better story, again, in the case is very simple. Qualcomm was not trying to maintain monopoly in the chip market and kill chipset rivals. It was using its market power in chips to enforce lawful patents. And the court might have conflated a licensing dispute between technology giants with market foreclosure. All right, so I'm moving to the end of the presentation now. So the solution that I advance in my paper is that we should develop a market power utilization test or plus factor. In the latest version, I use this term. This should be a plus factor in the analysis of monopoly maintenance claims. So the idea is this. So in the digital economy, we're seeing dominant firms on all sides of a transaction. This is relational dominance. And because these cases involve monopolies bargaining against each other, like Apple versus Epic, like X versus OpenAI, and Google versus Apple, and so on and so forth. We need plus factors to make sure we are not confusing who's the price taker and who's the price setter. So that market power utilization test would ensure that we are actually catching the firm wielding relational monopoly power in the particular case. And the idea would be to require proof that a restraint was enacted through an actual exercise of monopoly power. Something like a constructive or straight refusal to deal, a holdout, walking away, which is the firm that is really threatening the others and doing the holdout stuff. All right, that's the only way a monopolist uses its power. So if Google pays Apple a carrot, it's not really utilizing power. It is acting as a price taker. If Qualcomm uses chips to enforce its patents, it may be responding to holdouts. And by the way, Qualcomm did not hold out against rivals who got chips without paying any license, who could produce chips without paying any license. So the MPU test would ask, did the defendant essentially use a stick to force the deal? And if the defendant lacks the power to refuse a deal, the conduct could not be unlawfully exclusionary under Section 2. It's probably merely a contract with one player forcing the deal on the other side. Okay, so bottom line, the Grinnell standard, the precedent in Grinnell, requires willful maintenance. And willfulness requires more than a correlation. It requires more than a high market share, struggling competitors, and a conjecture that these two things work together, right? So the loose established framework of Microsoft for monopoly maintenance leads to judicial guesswork. And it allows Section 2 to be a weapon in contractual disputes where large firms try to sue each other over the division of spoils. We don't want this. This is not the purpose of antitrust. There are Supreme Court precedent that expressly say this. And so we should return to first principle. This requires to develop monopoly maintenance law through additional filter standards of plus factors to try to understand who is the price setter and the price taker in complex bargaining environments with relational dominance. The working paper is available on SSRN, and we didn't need to use the something that is a twin of myself. All right, thank you very much. I look forward to the discussion.
Thank you, Nicolas. So I guess we could reveal Plan B, which he hinted at. It was AI, Nicolas, giving this talk, which it was quite interesting. I watched it last night. I didn't know what to think about it, honestly. But with that and the ideas that Nicolas has shared with us, let me move over to Giovanna and get your reactions and thoughts.
Yeah, great. So first of all, thank you so much for having me here. It's a great pleasure. Thank you, Law and Economic Center. Thank you, John, all the panelists. And I'm pleased to have the opportunity to share a few thoughts on Nicolas' paper, which is very thought-provoking and compelling. I very much look forward to discussing this paper because I have long admired Nicolas' Petit work, so that's very nice. And I think, as you already heard, it's a very thought-provoking paper because, and my plan, I hope the slides work because the slides are there, I need to click there, so let me know if you get confused. So the plan of my talk is to cover briefly what are the factual and legal background of this paper, to outline the core contributions of this paper, and to offer a few thoughts and open questions for discussion. So let's start from the factual and legal background. So as mentioned, we are speaking about monopoly maintenance doctrine, law. And this doctrine, as you know, as you heard from Nicolas, stems from Section 2 of the Sherman Act, which prohibits monopolization and attempt to monopolize. And the Supreme Court, United States versus Grinnell in 1966 clarified that to monopolize a market, you need not only the monopoly power, but also the willful acquisition or maintenance of a monopoly. So, but Nicolas argues we don't really have a comprehensive Supreme Court framework to deal with this concept. We still rely on a three-step rule of reason framework analysis. So we don't, monopolies don't know what they can do legally. And Nicolas argues that, we still rely on a case-by-case assessment, and the case law, what has done today, so far, is to draw a line between lawful and unlawful conduct. And as you've heard from the author, the Google search case is the example, is the primary example to show why we need to think of the maintenance monopoly theory. So we need to fill this gap from the literature that Professor Petit found. So let me turn to the core contributions of this paper. So what Nicolas offers is a new test, because we don't have a structured test to assess monopoly maintenance. So in the paper, he introduces this market power utilization test, which requires to ask. So basically, courts should ask whether the alleged monopoly coercively deployed its market power to force the trading partner to adopt a restraint to competition. So if the test fails, the company is not liable. And this test, the focus of this test is exactly on the instrument deployed and on coercion. So the absence of coercion, so the coercion becomes the threshold to assess whether a monopoly is engaging in monopoly maintenance or not. And thanks to this test, the author argue that courts can now distinguish between conduct that stems from a superior product and the oppressive behavior. So let me open the discussion with, I'm a scholar, so every time that I think of Section 2 of the Sherman Act and theories related, I think, okay, how this test, I thought, is situated within the broader antitrust doctrine. So is consistent with the Harvard tradition, so is thinking about the monopoly power, so in terms of market structure and dominance of a monopoly, a durable monopoly, or this test is more consistent with the Chicago tradition, with its focus on conduct, consumer welfare, and error cost analysis. So I found interesting this test because from my perspective, okay, does Petit test combine in a certain way the Chicago style with a more structured concept of competition, because is considered a conduct, but at the same time, the theory stems from a market structure problem. So another thought that I had when reading the paper was, okay, so this test really focus on the coercion, so the coercive utilization of market power. So where is consumer welfare? So we are in the US, and the way we think about competition is in terms of consumer welfare. And the way to think of, the way I thought this test was in a certain way more similar to a regulating competition rather than consumer welfare focus. So I was wondering whether this test is by shifting the inquiry to coercion rather than effects on consumers is basically running away from the consumer welfare. So it's changing the traditional analytical framework of Section 2. And another thought I had, reading this paper was, okay, but if we are speaking about these monopolies, these agreements among monopolies, is there like a gap in the coordination of monopolies? So does this test with this higher threshold might leave a gap in the coordination, facilitating coordination among monopolies? And the other question I had, I would love to hear from the author, now or another occasion, is okay, how does this test operate in exclusionary conduct that are unilateral? Because if I have to assess the coercion, I would like to know more about how the coercion element works in, I'd say, predatory pricing, other conduct that are unilateral. Moving on, finally, last but not least, thinking about this dichotomy between acquisition of a monopoly and maintenance of a monopoly, I thought, okay, but the end result is always a monopoly. Indeed, in Europe, there is not this distinction between acquisition of a monopoly or maintenance. So if the end result is a monopoly, is really an important distinction, and especially considering digital markets that are characterized by network effects. So is this dichotomy, so this distinction between acquisition and maintenance of a monopoly reflect the reality of the present economy, and do the network effects blur the line between acquisition and maintenance? That's, I think, it's all, and thank you so much.
Thank you, Giovanna. That's a lovely picture of our school at the end. I don't know what's going on there. Tom, let me turn it over to you.
Great, thanks. Thanks for organizing. Thanks, Nicolas, for your paper, which I really enjoyed, and I agree with Giovanna. It was very thought-provoking. I really enjoyed it, and I think to some extent, I'm not sure how much it was intended to be comparative scholarship, but I think it's really the best kind of comparative scholarship, in that I think it does inform, or it's informed by some European ideas without strictly being a straight comparison between the two. And doing that, I think, gives us some real insights into the structure of American antitrust law, and really kind of crystallized some thoughts that I'd had about it that have been lurking, that Nicolas' paper really helped me land on, and hopefully we'll see help me articulate. So you can be the judge of how well I'm able to articulate them. I think Nicolas does a great job of addressing inconsistencies in the monopoly maintenance doctrine. There are definitely inconsistencies there, and in particular on the relationship between maintenance and acquisition. And I'll talk a little bit more about that in a second. And I think it's a great contribution for such a short paper, especially in part because he highlights some of the problems with how market power works in monopolization cases. Very often, courts, market power is one of the elements of a Section 2 case, along with anti-competitive conduct. Courts will rattle that off, but they don't tend to do such a great job of describing the relationship between them, if there is a relationship between them. Are they just two elements? Do they work together? In some cases they do, in some cases they don't really. And so the anti-competitive conduct isn't as closely related to the market power. And I think that Nicolas' paper really brings that out. So I think there is some inconsistency and incoherence there. I think Nicolas is right. So I would make 2 points. The first is I think Nicolas is right, that the maintenance acquisition distinction is somewhat incoherent in U.S. antitrust doctrine. My second point is I think that's probably okay. And while I think it clouds the doctrine, I'm not sure that it substantively leads to different outcomes in a lot of Section 2 cases. And so it's a little bit unusual to say that doctrinal indeterminacy is okay, and I generally like clear doctrine. So let me explain why I think it's okay. So, of course, Giovanna sort of pointed this out, and Nicolas talks about it a lot in his paper. The maintenance acquisition distinction is not in the statute, it's judicial gloss. You can talk, I think it was formally introduced in a couple of different places. I think it's largely introduced by Judge Hand in Alcoa, although I'm not sure how carefully he maintained that distinction, which is a point that Nicolas makes in the paper. And to some extent, his theory of liability in that case, which I think is received to be quite broad, maybe didn't lead him to distinguish between acts that might have been acquisition or maintenance. And you get something similar in cases like Griffith, where the court recites both acquisition and maintenance, but really analyzes the case under one of them without parsing them out very carefully. So they get deployed together, but courts don't often go down distinct routes as they're analyzing the case, saying, oh, well, this one part of it is acquisition, and this one piece of conduct they did, this is about maintenance. And you do see it in some cases, but it's pretty rare that courts will actively distinguish between the two of them. And I think that's because the defendants tend to do pretty similar things with regard to acquiring monopolies as they do with regard to maintaining them. Where I think things kind of go awry are in cases like Berkey Photo, which again features prominently in Nicolas' paper, where the judge distinguished acquisition and maintenance into two distinct theories. One, acquisition, which is acquiring market power, and maintenance he identified as the use of market power to maintain control, right? And it is no less true that a firm with a legitimately achieved monopoly may not wield the resulting market power to tighten its hold on the market. That's, I think, a specific form of anti-competitive conduct. That's a leveraging theory, where a defendant tries to use their market power and leverage it in some way, either to obtain some preference or maybe into another market. And leveraging, I think, was a somewhat more popular theory at the time Berkey Photo was decided. And it's at least one way to look at what Kodak was doing in that case. And I think Nicolas, who similarly focused on the use of market power, is advancing something of a leveraging theory. But I don't think that, and to the extent that he is advancing a leveraging theory, I think that some of his treatments are interesting. I'm not sure about the pricing thing. I'll come back to that in a few minutes. But I don't think leveraging is the only theory for monopoly maintenance claims, right? I mean, interestingly, I think in Berkey Photo, and at the time, people saw leveraging as a way to expand the possibility for monopoly maintenance claims. And in this paper, actually, I think Nicolas is almost limiting using leveraging as something of a limit on maintenance claims. And I think that they might be somewhat broader than that. So I think, because there are any number of Section 2 claims in which there's the presence of market power, but not necessarily leveraging. I think Microsoft is a great example of this. I'm particularly sorry to have missed the panel on Microsoft today, especially if they said something that's factually inconsistent with what I'm about to say, which would be embarrassing. But some of the theories were dependent in Microsoft were dependent on leveraging. It is a lot of conduct in Microsoft. Some of those theories look like leveraging theories. Some of them do not. Some of them, some of the license restrictions and conduct related to Java, for instance, and things like that don't look like leveraging theories at all. So I think that raises the question of what it is that the maintenance theory actually accomplishes. So if it's not a distinct form of conduct, and what is it doing? And I think it does a couple of things. First, and Nicolas just referenced this a little bit, and it comes out a bit in Giovanna's discussion, it shifts the defendant's economic baseline. So in an acquisition case, a defendant's working to acquire monopoly power. In a maintenance case, the problem for any monopolist is that markets tend to erode market power, and so you've got to do something in order to maintain it. And so the defendant's baseline shifts not from acquiring, but to preventing erosion, right? And so And so that's one of the reasons why I think it's easy for courts to fail to keep the two theories distinct, but it's also why I'm not sure that there's a major substantive problem with that, because it's the same kind of conduct. It's just happening at a different time in the life cycle of the monopoly. Alcoa, I think itself is a perfect example of that. As I mentioned, one of the reasons why I think Judge Hand has a hard time distinguishing between some of the acquisition theories and maintenance theories is because the line between acquisition and maintenance is not that clear necessarily, right? So did they acquire their market power, for instance, by virtue of their patents? That's what he talks about. They have intellectual property. Then they entered into these exclusive contracts for electricity and engaged in a number of things like expanding output. At what point did they stop acquiring and start maintaining? I don't think it's necessary to identify that point doctrinally, although I think it's helpful descriptively, which leads to my second purpose for maintenance, which is that it's a framing device that explains conduct by a monopolist, often in a different market. So I think that one of the problems that comes up in these cases is that monopolists, in order to maintain market power in one market, will engage in conduct that actually affects another market. I think that's actually what happened in Google. And it's the quintessential example of this is Microsoft itself, where Microsoft looked like they were engaging in all this anti-competitive conduct to acquire a monopoly in browsers. They were trying to exclude the Netscape browser, and so the market price of a browser at the time and now is zero, right? So are you going to make it up in volume? It's hard to figure out why you'd want to monopolize this market. Well, their purpose in engaging in exclusionary conduct in the browser market was to protect their monopoly in the operating system market. It's a different market. And the maintenance claim, or the framing of it as a maintenance theory, makes it easier to conceptualize that shift from one market to another. And I think that that's a particularly important shift in digital markets, where market definition is very hard to do. Because unlike in more traditional markets, products are largely conceptual. They're intangible. Is social media and messaging, are those two different product, right? Are YouTube and Facebook in the same product market? I don't know. Maybe a case will come out on that. But it's very hard to do market definition in those cases, or it's hard to have an authoritative understanding about it. And the maintenance claim helps to explain why conduct that looks like it's anti-competitive in one market is actually about another market. And acquisition, just as a narrative point, or as a narrative vehicle, doesn't describe that very well. And so in that way, I think it's really better to think of maintenance in those terms, at least in those markets. It opens up the aperture to look at what would be anti-competitive conduct by the monopolist. I think that could be leveraging, as Nicolas talks about, but I don't think it has to be limited to leveraging, which means that if your theory is not a leveraging theory, then I think that trying to price the exclusivity that was purchased might be a little hard to do. I do think as a separate matter that pricing exclusivity is kind of a hard way to measure market power. Monopolists, monopolists will pay in order to maintain their exclusivity, and watching the cash flow doesn't necessarily indicate that they don't have market power, maybe maybe not in that market, but in some other market. So while I think it's better for courts to be explicit about the acquisition maintenance distinction, I think largely the same substantive rules should apply. And I think descriptively, that's what's happening in courts. The same substantive rules are applying between acquisition and maintenance claims. It's largely a matter of framing. And so although you see some statements in the doctrine that they're really two distinct theories, I actually don't see courts generally treating them that way. And I'm not sure that that's such a bad thing. I do think courts should do, and I think Nicolas' paper is great for this in pointing out this problem. Courts should do a much better job of describing the relationship between the two elements in monopolization claims. Because, like I said, in some cases, the relationship itself is not that clear. And sometimes one really leads to the other, and this goes to a point that I think came up a little bit more in the presentation and in the paper, a point about causation. And I know that was a feature earlier today as well, that trying to make that causal connection to explain what's happening in the case, I think that's going to be that is becoming a bigger issue in antitrust as we explore some of these theories. And I think one of the ways to do so, and one of the ways to explore how causation works in these cases, is to think about the kinds of connections that Nicolas is drawing in his paper, for instance, between anti-competitive conduct and market power.
Thanks, Tom. And yeah, that first panel on Microsoft was terrific. But of course, you had a very good excuse. You were teaching con law at the grounds of University of Virginia. So I'm thankful that you were able to make this panel. So I know I'm not the third discussant, moderator, but just to add a little bit, because Tom, you mentioned something that I wanted to raise, and I want to go back to Nicolas to get his reactions to this. Is first, I do think the paper is worth downloading and considering for the mere fact that I do think he makes a very good case that the case law and doctrine of monopoly maintenance is not as well formulated as we, or at least I presumed it was. I'm thoroughly convinced that it's underdeveloped and there's parts that are sort of vulnerable to criticism that I think is quite right. Another element that, Tom, your remarks made me think of is that we have this sense of power, right? Obviously, to maintain monopoly power, you have to have it. So you have it, and then you do some conduct. And what's the link between the two? And as Tom mentioned, sometimes there's this sort of presumption. We can talk about whether strong or weak or what other evidence you need, but once you have it and whatever that conduct does has some effect, it's close enough to have a causal inference that that's helping you to maintain that market power that you have. We explored a little bit of that in the first panel. But I think what Nicolas's paper is doing, and I know you don't have the benefit of having read it, is he's introducing this MPU, market power utilization element, to say, do we need another element to establish that causality? And the way he does it is he suggests, well, what you need is some level of coercion of your trading partner. So when you have Microsoft and OEMs, and Microsoft says, hey, don't preload Netscape, that fits well within Nicolas's MPU test, saying there's coercion of a trading partner due to your market power. Don't deal with this new product, just deal with me, and then life will be better for both of us, but obviously not for Netscape. Whereas in US versus Google, Nicolas raises that question, as his presentation indicated. Hey, there's a lot of payment going from the monopolist to Apple. Who's coercing who? And if you can't set that up cleanly, are we maintaining step one, and is there a real causal connection between the default agreements for Safari and the maintenance of that monopoly? That's how I read it, and I think, Tom, your comments really illustrated that to me. But before I go on any further and just dominate the rest of the time here, let me move to Nicolas and to see if you have any reactions to the excellent remarks by Giovanna and Tom.
Okay, thank you. Can you still hear me?
Yes, we can hear you.
Okay. Very good. I'm very grateful for the excellent comments from Giovanna and Tom and John again. I can add a couple of thoughts because these are remarks that suggest extensions or call for increased sophistication in the paper. So I'm going to just try to talk a little bit to the various points you made in the hope that I can address some of your concerns or critiques. So the first thing I want to say is I have another paper, so that is self-referencing, on which is called Understanding Market Power. And this is actually a true comparative law paper that compares US antitrust law with EU competition law that I criticize heavily. I think US antitrust law in a way is more developed than EU competition law, is more clear and logical and economically sound actually than than EU competition law. But in that paper, I say something that I think is a bit connected to that paper, which is that in any Section 2 or Article 102 case, you have three market power facts that can matter. You need to establish some market power base. You need to show some market power utilization, and you need to show a form of market power injury. Right? These are the sort of three ingredients in any Section 2 or Article 102 case. And US and EU law tend to put the weight up or down on each of these facts. So oftentimes, in EU competition law, for instance, the market power injury is almost presumed. We don't need a very strong showing of consumer harm or, output going down or, prices going up. It's like sort of assumed. By contrast, in US antitrust law, this market power utilization fact is something that's often taken for granted. The mechanism that connects the base of market power with the market power injury is unclear. And I think this is the point I'm trying to make in this paper, which is that you cannot run these Section 2 cases against firms and threaten them to dismember their businesses and divisions and units and segments if you cannot articulate the mechanics of market power that underpin harm to consumer harm. That is not acceptable in the system of law, that you would be able to get away from explaining how the theory of liability works on the facts. And I think thinking about market power utilization is good, because it's advantageous relative to the other discussion that we're having on causation. Because in causation, there's always this rebuttal that you hear, which is it's impossible to reconstruct the but-for world. You're asking for a proof that is unmanageable. No enforcer can prevail on that, or no plaintiff can ever prevail if you're asking to reconstruct the but-for world. So instead of focusing on causation, a more productive avenue to improve Section 2 doctrine consists in explaining the mechanics of coercion or the mechanics of holdouts that are the link between the market power base and the market power injury, right? So I think this is in a way the mistaken path on which Microsoft set Section 2 law is to frame this as a causation problem and putting the weight down on causation by having these very edentulous, amorphous, very light standard for causation, which is a problem because now we don't have the mechanics are very hard to explain for liability. The second point that I just want to make, and I'll be very brief on that, is it's a point that John, with his very good eye, picked up in a previous presentation of the paper where he was commenting, is that I focus mostly on vertical foreclosure cases. And it is probably interesting, as Giovanna and some were hinting, to also study cases of horizontal monopoly maintenance, so which could be predatory pricing cases, which could be monopoly maintenance by merger, so that the Facebook within the Facebook, WhatsApp, and Instagram cases, right? And in these cases, this test of market power utilization becomes extremely difficult to apply, right? What is the coercion? Is it coercive to buy a company for $10 billion? So how would you formulate your market power utilization test in an M&A context, for instance, right? And so I think this is very hard, and it's a productive direction for progression for the next version of that paper. So thank you to all three of you for the great comments.
I look forward to reading your follow-up papers.
So it makes me think, Nicolas, you mentioned, I like that distinction between vertical monopoly maintenance versus horizontal. And I was thinking the same thing about horizontal having less application to what you're doing. But I don't know, me personally, find it problematic that horizontal and vertical have different elements, but maybe that's complicating monopoly maintenance beyond that. But before I turn to the audience for your reaction or questions or clarifications, I just want to turn to Giovanna and Tom to see if there's any other thoughts you wanted to share, given what Nicolas has just said.
I think mostly I would say what Giovanna said, was I'm looking forward to the next version. I mean, I think, as we've seen it develop a little bit, Nicolas is very responsive to issues that have been raised, and so I'm just looking forward to seeing it develop.
Yeah, honestly, this paper made me think of issues I never thought, and from perspective that, I would not instantly think of. So it was, as mentioned, thought-provoking, so I encourage you to read it, and I look forward, to reading the second one.
Okay, great. So let's open it up to the audience to see if there's any reaction. Again, you did not have the advantage of having the paper in front of you, but I don't know if this invokes strong feelings or you're like, yeah, okay, it's not clear, so let's clear it up. Any thoughts? Alden, go ahead.
This center. The paper sounds very interesting, and look forward to reading a draft of it. But my question is, I think somebody who's here today, Greg Warden, has advanced and didn't come up directly this discussion. The rather controversial, though I think there's a lot to be said for it, no economic sense test. So, for example, looking at the payments to Apple by Google, you'd ask yourself, with regard to any behavior, rather than putting it into a structure, say, does this behavior make an economic sense, but for harm to competition, competitive process? And in the case, I think, of the payments to Apple, they were credible, I would probably slotting allowance type arguments. That in fact, it was sharing some of the rents in order to be able to get some marginal consumers. And also, Apple also was a beneficiary in terms of its own, what it was trying to develop and sell. So you could argue, if you buy that argument, I'm not saying it's correct, but you could say, aha, these strange payments, well, if there's a credible no economic sense test answer, then you have it. So I think the common law process seems, as it's evolved, is a little bit different, and trying to move away from, we earlier heard about the problem about Jefferson Parish, one result if it's tying, another result if it's exclusive dealing. The real way to handle these things is perhaps just looking at the nature of the behavior, how it affects the ability to maintain a monopoly or not, and if it passes the non-economic sense test as not problematic, then you don't have a problem.
Thanks so much, Alden. Appreciate that. Nicolas, did you have any reaction? Are we to AI, Nicolas? Okay, no, it's thankfully the real.
I don't know if we
Nicolas.
can handle AI.
I want to see AI.
It's uncanny. But go ahead, Nicolas. I don't know if you have any thoughts to what Alden shared.
Yeah, no. So I think that's a great way to deal with these allegations. Say, hey, come up with a good justification, and we're going to look into this, and this will play in the case as a way to dismiss the theory of liability advanced by the government or plaintiff. And actually, what Giovanna recalled, it's actually structured in the rule of reason. That's the three-pronged test that we use to, give the defendant a chance to argue that the conduct makes economic sense and there's a good justification. The problem is that in these cases, the evidence is so blurred that it's very hard to come out with a clean justification that is neither so obviously true that it compensates the harm to competition showing of the government or the plaintiff, or even if you have it, it could be that there are possible other competitive justifications for the conduct, it's not clear which one it is, right? So in this Google US versus Google case, for instance, one other competitive justification could be a meeting competition justification. Oh, Apple is developing in-house search. You are trying to, meet this competition. Well, and so the problem is that this subjective justification thing is a nice idea in antitrust theory, but it's very hard to implement in practice. And the common law process shows very well that these objective justifications are often dismissed because they are competing stories, and it's very difficult to solve between them. And even when you have a clean one, it's very hard to gauge it against the sort of tangible showing of anti-competitive harm. And so most of the times you really fail to argue as a defendant on that ground, right? I mean, there are so many good justifications for exclusive dealing.
Any other questions from the audience? So one thought on the Apple agreement. I thought a big fact that Nicolas has, of course, referenced is that part of the agreement wasn't just the $20 billion, but there was a pre-approval right that Google had on any new search feature that Apple would introduce on the iPhone. I thought that was pretty eye-opening, and it tends for me to suggest, as you rightly point out, maybe not Section 2, but Section 1 in terms of some agreement not to engage in search unless there's a meeting of minds between Apple and Google. Now, of course, I'm just speaking out loud, speculating, but I found that fact under-discussed and consistent perhaps more with alternative hypotheses that Nicolas was proposing earlier. But with that, Tom or Giovanna, did you have any?
I share, you and Nicolas thought about, okay, shall we consider Section 1 rather than a Section 2 violation? I think, there might be facts, issues that make us thinking about, okay, maybe this is not really like a unilateral conduct, but it's more like an agreement. So I really appreciate that you pointed out, and I think, and also Nicolas' paper actually, I think, raised the problem, raised the issue, and I think it's important.
I mean, I think throughout, one of the things that struck me in the paper that I've been thinking about and is sort of highlighted by this conversation is this role of coercion. Yeah. So, that seems to be the kind of the linchpin of the paper is, the defendant has to be using their market power in a way that coerces this partner. And I kind of wonder how central that has to be to these theories, so that if your theory is that it's not that the anti-competitive conduct, right, not the existence of market power where there's going to be coercion in that market, but that the conduct itself has to be coercive as opposed to being something else, that it's got to be outside of Section 2. And I think that's something to think about as well. That certainly seems to be a motivating feature, Nicolas. We lost Nicolas. And it just, he's back. He's very big, and I turn around and he's there, and seems to be pushing towards the Section 1, Section 2 line. And I think it's one of the things that I keyed on when I was reading the paper and the concern about the way that the money was flowing. So I think that would be something that would be helpful to flesh out a little bit more in the next draft, talk about the role of coercion a little bit more.
Thanks so much. And I know there's something happening after this talk as well. So we're pretty much right at time. So please join me in thanking Nicolas, Tom, and Giovanna. Thanks, Nicolas. Appreciate it.